Welcome EPG Pathshala. I am Kamlesh Kumar from Tata Institute of Social Sciences. I am talking about module on handcuffing. Handcuffing, an introduction, prevention of crime and apprehension of criminal, the prime responsibility of the law enforcement agency, so-called police, in process of justice, in found all over the countries in the world, albeit their names are maybe different. Somewhere they call as a police, law enforcement, and law enforcement agencies. Police is the first agency of criminal justice system and also considered as a gateway of justice process. Hence, it enjoys a lot of legal power and authority to stop your movement. They can search and seizure any suspected articles, particulars belong to the suspected person, accused and sentenced persons. Those who process in the law and they come by law to in their custody. The police custody for basically is two regions like security of safety of the society and taking the preventive action against the accused. Police using handcuff to the accused person in different situations. Also other agencies of criminal justice such as prison and correctional authority also using the handcuffing to the accused and suspected persons in their judicial custody. Within the premises of prison and jail authority, they are escorting accused person to the court, escorting the accused person to the hospital, and also taking back to the prison and jail premises. While doing this, they are also using the handcuff to the accused persons for various reasons. The handcuffing is not allowed generally in the law unless until the magistrate approves or given the permission to do so. Handcuffing is a violation of human rights in a civilized society ruled by law in India. In different circumstances or situations, the law enforcement agencies are allowed or permitted to do so. An accused may be handcuffed or forfeited for various reasons. Otherwise, it is a violation of human dignity and human rights and also legal rights of an accused, those who are in process of law. The experience from the field have been suggested that it is not always easy to prevent the accused from the escaping due to a lot of complexity involved in the crime situation. At this juncture, the police use the tactics of handcuff to keep the offender under the control of his custodian. For that reason, the police are easy prey for human rights violation also or misusing their authority while handcuffing or putting a person in their custody. This is a very paradoxical situation. Put a police and prison authority in the dilemma whether they use the handcuffing or not, whether the demand of situation or warranted conditions prevail. Sometimes the henchman or the gang person of the accused, they are trying to take the custody of accused by forcefully and use the violence against authority of police and prisons. In these circumstances, the police use the handcuffed person and put him or her in a safe custody. However, in many situations, handcuffing was considered as a human rights violation by judiciary and quasi-judicial bodies, so-called human rights commissions and committees. Handcuffing has a constitutional and legal implications. Why Constitution of India offers all citizens, individually and collectively, have basic freedoms and rights, and these are the guaranteed in the various articles and provisions under the Constitution of India. These freedoms and rights of accused under Article 14 to 35 contains various liberty, freedoms and human rights which are related with right to equality, provision of discrimination on ground of religion, race, caste, sex, place of birth, and equality of opportunity in matter of opportunity of employment, right to freedom of speech and expression, right to make assembly, association or union, right to movement, residence and staying any parts of country, right to practice any profession, occupation and other right to subject to security of state, friendly relation with foreign countries, public order, decency or morality. Article 21 of the Constitution has provided right to life means decent standard of life, which implies not only the ordinary citizens but alien and even criminals, those who are awarded capital punishment and waiting for their execution, has all the rights and freedom until they die or executed by authority of law. The Supreme Court, while upholding the concept of personal liberty, rejected the hands-off doctrine and ruled that fundamental rights do not flee the person as he both under trial and convict. Human dignity implicit in the right to life and personal liberty incidents in Article 21, including against handcuffing and forfeiting of prisoners. So it is well settled down the principle that Article 21 provides right to life and liberty that cannot be taken away arbitrarily except according to the procedure established by law. The procedure established by law to take life of person and liberty curtail be just, fair and reasonable. For that, Article 14 provided equal protection of law for every citizens, handcuffing violation of constitutional right to equality before law or equal protection of law. In a leading judgment of Prem Shankar Shukla versus Delhi Administration 1980, the Supreme Court of India has laid down certain guidelines in dealing with under trial prisoners or suspected persons, those who are in the custody of police and judiciary, while arrest and detention, and force them handcuffed to produce before the nearest magistrate, and subsequently being the court for hearing the cases and the process of justice. These directives of guidelines issued by the Apex Court proved as a safeguard to the under trial prisoners and convicts both in the custody of state. Further directives to the police and prison authority: when they take a person in their custody, they must be borne in their mind that every prisoner has dignity and human rights against handcuffs. Under the directives, it should be followed by the authority of law. In case of failure, they will be deemed contempt of court. These guidelines are the follows. Handcuffing is prima facie inhuman and therefore unreasonable and arbitrary. The competing claim of securing the prisoners from fleeing and protecting his personality from arbitrary have to be harmonized. Insurance against escape does not compulsorily require handcuffing, and there are other measures whereby an escort can keep safe custody of a detainee without the indignity and cruelty implicit in the handcuffs or other iron contraceptions. If a few more guards would suffice, then no handcuff. If the close watch by armed policemen will do, then no handcuffs. If alternative measures may be provided, then no iron bondage. This is the legal norm, save in rare cases of concrete proof readily available of the dangerous of prisoners. in transit in the onus of proof of which is on him who puts the person under iron. The police escort will be committing person against of may him if the handcuffs or fetters his charge. Tangible testimony documentarily or other or desperate behavior agreed to making good his escape alone will not be valid ground for handcuffing and forfeiting. And even this may be avoided by increasing the strength of escort or taking the prisoners in well-protected vehicles. These measures would ordinarily serve the alternative safeguards, and even in cases where in extreme circumstances handcuffs have to be put on prisoners, the escorting authority must record spontaneously the reasons for doing so. In cases of under-trial prisoners, the escorting officers, whenever he handcuffs a prisoner produced in the court, must show the reasons so recorded to the presiding judge and get his approval in the Court of Criminal Procedure 1973. The sections pertaining to the mode of arrest, detention and custody as well as search and seizure are relevant as far handcuffing is concerned by police for ensuring safe custody. The police custody commences a person when he or she is arrested. The arrest may be legal or illegal. It may be formal or informal. It may be by words or action. Every arrest amounts to custody, but not vice versa. Arrest and custody are not in all circumstances. Arrest is a formal mode of taking a person into custody, but a person may be in the custody in other ways also. Whatever be the origin of custody, it has an important consequences that it deprives the liberty of person being arrested or detained in police custody. A detainee's movement, action and even thinking comes exclusive control of custodian. Thus, the personality of a detainee becomes subordinate to the person under he or she is placed. This situation of mastery and domination over body and mind generate various types of abuses in the custody of police, so-called custodial commission of crimes in police custody. Let us have look at person escaping from custody and need arises for handcuffing. According to Crime in India 2015, a total number of 5,172 cases were registered under section 224 and 225 of IPC during last 5 years, wherein 6,196 persons escaped from police custody, and out of 30 persons who lost their life while escaping through police custody. In prevailing scenario, regardless of the statistics figures, the phenomena of escaping itself is manifestation of power dynamics and viewpoint in the state custody by custodian. Especially law enforcement agencies or police engage in this escorting prisoners from one place to another place for court hearing or court appearance as case may be required the need of law. Escaping in other regions, handcuffing and judicial response in case of Citizens for Democracy versus State of Assam in 1995, the court has observed that between prison house and courthouse is freedom from handcuffs. Maidhar Bipul Das case, an Ulfa activist in custody escaped having regard to the number of Tata detainees escaping from police in judicial and hospital custody. We are therefore in the view that the action of respondent is justified. So in another case like Jaswinder Singh case versus Karnataka Criminal Petition number 176 of 2002 year, the criminal jurisprudence denies allegation of torture, obscene gesture, etc. A copy of police record dated nil and without disclosing the author of same is filed stating that while first and second petitioner were taken to the prison on their conviction, they turned violent not only inside the court but also outside the court, and they were taken to the prison while the help of other members of police force. The constable who was among the team who was in the charge of the escort party also has shown to an affidavit stating that the prisoner in this case in the jail being handed over by the court after their conviction, and they took them to the prison by handcuffing them under a bona fide belief that situation might become worse. He was cited that MP police regulation in support of his action of putting the prisoners under shackles. One person supporting affidavit also filed a constable of the escort party. It seems that a sub-inspector of CID made an inquiry on a petition regarding the handcuffing of prisoners, submitted his report to the Superintendent of Police. The relevant portion of the report reads as follows: the handcuffing of these petitioners while being taken to court from the jail, we are very much distressed the way in which the respondents have come forward to explain their conduct of handcuffing of petitioners while being taken from the court to jail, but make no whisper about the handcuffing from jail to court. We make it clear that the law laid down by Supreme Court in the leading two judgments, Sunil Batra and Prem Shankar Shukla case, and the directions issued by us are binding on all concerned, and any violation or circumstances shall attract the provision of the contempt of court. Apart from the other penal consequences under law, this court in Batra's case and Shukla's case elaborately dealt with the extreme situation when the police and jail authorities can resort to handcuffing of the prisoners inside and outside the jail. It is a pity that the authorities have miserably failed to follow the law laid down by the court in the matter of handcuffing of prisoners. The directions given by the court are not being followed and are being treated as a pious declaration. We take judicial notice of the fact that the police and the jail authority are not even now using handcuffs and other fetters discriminately and without any justification. It has therefore become necessary to give binding directions and enforce the same meticulously. Handcuffing and contemporary challenges. In the given circumstances, data and figures prevailing in the country, the authority of police and prisoners, they are in dilemma to use handcuffing in the cases of notorious and powerful criminals who could be threat to the society and safety of many. Thus, the view of handcuff violates fundamental rights guaranteed in the law of land. In all the cases where a person arrested by police and produced before the magistrate and remained judicial or non judicial custody is given the magistrate, the person concerned shall not be handcuffed unless special orders in that respects are obtained from the magistrate at the time of grant of remand. In another case of Kishan versus State of Maharashtra, this is the latest case of 2013. The accused was illegally arrested in chapter proceedings case and unjustified his detention and custody under the law. Further, it meted out inhuman, cruel and degrading treatment by being paraded in the street while handcuffed. He submits that there was absolutely no justification for handcuffing by the police, as there was never any threat of his escape from the custody, nor he was there in any material to show the promptness of a petitioner to escaping from custody. It is also well settled law and merely because the offence is serious, the law enforcement agency, assuming that the inferences of escaping from the custody, therefore, in this case, some tangible evidence, documentary or otherwise, of desperate behavior directed to make aspect of human rights, not handcuffing. In majority of the cases have become challenging tasks handled at the grassroots level. In sum or summary, it can be said that handcuffing is a inhuman act and also violation of human rights, human dignity of accused and prisoners. However, the practice of handcuffing by police and prison authority for various reasons in contemporary time increasing because of the time in change, crime is increasing, insecurity prevailed in society, particularly intolerance resulted riots and lynching cases by the public or mob. As a result, ensuring arresting safety of accused and bring them to the justice process becoming a challenging task for law enforcement or police because of great chances of escaping from custody. Moreover, party politics along with nexus criminal made the situation worse for maintaining law and order that was threat for everyone in social life. Looking the gravity of situation and circumstances, most of the time police use and justify handcuffing to the accused to ensure safety and security of the society and reduce repeating crime or recidivism. As a result, police usually pray for human rights violation. Police is also in dilemma for handcuffing or not. However, after releasing many directions by the courts and commissions, advisory by the governments, the practice of handcuff became unbeaten phenomenon due to context, reality of crime and security prevailing in the country. Thank you very much for watching this video.